Hello, everyone, and welcome to this month's webinar on the Department of Labor's proposed regulations addressing overtime, joint employers, and regular rate of pay. This free webinar is available exclusively for our customers enrolled in our subscription services. I'm Leon Frierson, the Publications Coordinator for Personnel Concepts, and I'll be your moderator for today's webinar. Now, our guest speaker today is Christopher Ray, a Boston-based attorney licensed in Massachusetts and New Hampshire. Mr. Ray began his career as an in-house counsel for a large Denver-based technology company, working mainly on employment matters, data privacy issues, and contract matters. Since going into private practice, he has served on both the employer and employee sides of litigation matters, including litigation before the EEOC. He also provides regulatory compliance guidance for businesses in high-risk verticals, such as cryptocurrency and the legal adult use cannabis industry. In partnership with the PHR certified HR professional, uh, he is also provides compliance training, ERISA plan design consultation, risk management, and employment law guidance to employers not currently in active litigation. He received his JD from Suffolk University Law School, graduating with distinction in an elective concentration in labor and employment law. Thank you, Christopher, for joining us today. We much appreciate it.
Thanks for having me, Leon, and hi to all of our guests. Good morning to those on the West Coast. Good afternoon to those on the East. I'm looking forward to discussing today's topic of some recently proposed Department of Labor regulations. I think it's a very pertinent area of law that will certainly affect most employers.
Definitely. And we are definitely looking forward to discussing it with you as well. Now, for our audience, today's agenda focuses on providing an overview of each of the proposed rules, including overtime, joint employers, and regular rate of pay. And after each section, Christopher will go over tips on what employers can do to prepare for the final rules of these proposed regulations. And then at the end, we'll address questions submitted by your listeners, by the listeners today, the audience, you guys. Thank you guys for coming. Now, the format for today's webinar features a series of questions that we'll be asking to Christopher regarding preventing race discrimination in the workplace. Preventing or discussing the overtime joint employers and regular rate of pay. And before we want to begin, though, I do want to invite everyone in attendance to submit any questions you may have during the presentation by using the Ask Question feature in GoToWebinar. You can also pose questions in the question window. Now, most questions will be saved for the end of today's session, but those that are relevant to today's subtopic being discussed will be posed where appropriate. And at the end of the session, you will have an opportunity to use the raise hand feature in GoToWebinar to pose a question directly to our guest speaker. Now, with that said, let's go ahead and get started with today's presentation. And Christopher, let's start off. The Department of Labor has certainly been busy these past few months proposing updates to 3 regulations. Now, most employers have probably been following the news about the forthcoming overtime rule. Could you give us a quick background of how the overtime rule update came about in the first place?
Sure, Leon. So the rule that is before us right now is actually the same rule that was proposed in 2016. Those who follow this area of law closely may remember that there were some updates that were proposed to this rule in late 2016. That rulemaking was rejected by the Fifth Circuit on appeal entirely on technical and procedural grounds that had to do with how the notice and comment period was run. It had nothing to do with the substance of the rules. So the actual substance of these rules has never been challenged in any court. We can speculate on what litigation might bring forth in the future, but from my view of it, there's nothing objectionable in the content of the rules. And so given that they've revamped the comment period procedure for this version of the rulemaking, I think it's likely that what's before us now either is or is very similar to the version of the rules that was proposed in 2016. So the latest version of these rules was set forth on a March 7th notice. The notice and comment period has run and has since closed, and they're going to need some time to sift through the public comments that were received on these rules. So it's possible that there may be some slight changes made to the rules that we're going to discuss, particularly to the actual numbers that go into the overtime eligibility calculations. But I don't think that the substance of the final rule that's going to come out is going to be materially different from what we're going to see from this notice of proposed rulemaking.
Thanks, Chris. And then before we do hop into the proposed rule, could you review for us what the current overtime exemption rule requires?
Sure, Leon. So, as a general matter, overtime is calculated as 1.5 times an employee's base rate of pay for hours worked during any week with 40 hours of time worked in a given week. So, as I'm sure many in the audience are painfully aware, there's a lot of state law variation in these calculations. State laws can't make the rules less favorable to employees, but a lot of state laws grant different levels of protection or a different basis for calculating how overtime is derived based on what kind of work is done, where you work, whether you're on call, that kind of thing. And there's also some wiggle room under state laws to contract around some of these protections. And so something that you're going to see in these rules is that they are designed in part to streamline a lot of this state by state variation. Those in the audience who practice mainly in California will be relieved to see that the version of the rules that we're going to be looking at, both in this area and later in the joint employer rules, is largely based on the current California labor law regime. As is it should be familiar to anybody working in this area right now. Workers can be exempt from overtime payments if they're both in a category of job duties that's eligible for exemption. And we'll go into more detail on that job duties test later. And if the employee meets a minimum salary threshold. So the minimum salary required right now is about $455 per week. This is one element of the overtime rules that is being changed by the proposed rule. And then there is a ceiling to this compensation. There's a concept of highly compensated employees, those earning 100,000 or more, who, generally speaking, 99+% of the time, with very few exceptions, will not be eligible for overtime, no matter how their pay is calculated. The Fair Labor Standards Act provides an exemption from both minimum wage and overtime pay for employees who are involved in certain job duties that qualify for exemption. And this job duties test should be familiar to most HR professionals. Those are employees who are in executive roles, those who are in bona fide administrative roles, those who are in complex professional roles or outside sales employees. And also it applies to certain computer working employees, but that's not just anybody who uses a computer. Those are IT professionals, people who need a certain level of computer science specific knowledge to do those jobs. So to qualify for the exemption that exists under the current law, you have to both meet the tests that relate to these job duties, and you also have to be within the salary thresholds that we discussed on the previous slide. One thing that we'll see in this rule is that the job duties test is not going away. There is a separate proposed rulemaking that is outside the scope of this webinar, but that I'm happy to refer you to afterward, that clarifies some of the limits of the administrative exception. But the job duties test, as it currently stands, is not being substantially modified by the proposed rules.
Thank you so much for that. And in response, we're actually going to go ahead and launch our first poll for the audience. So if everyone could pay attention to your screens, I'll go ahead and get that up on there now. And what we need to know from everyone attending today is, does your workplace utilize discretionary bonuses? So this is either a yes, no, or an I don't know. So if everyone can go ahead and tune in now. I do see the results tallying pretty fast, so thank you for your quick response. I'll give you about 3 more seconds here, Chris, and then we'll move forward. All right. And I'll share the results as well. So based on our audience's responses, it looks like about 46% do, and a little concerning, about 21% are not sure. So Christopher actually will be discussing with us how discretionary bonuses will be a key aspect of measuring compensation under the proposed rules. So with that, I need everyone to make sure that they are paying close attention, especially those in the I don't know category. So Chris, going back to the presentation here. So now that the rule discussed So that's the rule that exists today, the one that we just discussed about the overtime, the 1.5 times, and how they should be currently doing their calculations. Could you discuss with us what the DOL's proposed overtime exemption would require in the future, please?
Sure, Leon. And I think that your poll is well timed because discretionary bonuses are sort of in that gray area, or at least they have been in the past about how overtime is calculated. So we'll be talking more about that on the next slide. Hopefully, clear things up for some of those I don't knows in the audience. So I'll start by pointing out here that this rule has not yet been finalized. So the information that I'm going to present is still technically a proposal at this point. As I discussed earlier, though, I think it's unlikely that the real substance, the real meat of these rules is probably not going to change between now and finalization. We may see some wiggle room on the numbers, on the specifics, but I think that the real substance here is not going to change. And so when that rule is implemented, it will apply going forward, likely beginning with a full calendar year. That's how DOL likes to do things. So you might see the rule go forward for 2020 and beyond, or 2021 and beyond, but nothing retroactive. You're not going to have to worry about going back and revising payments that you've already made. These rules will all be forward-looking. So the comment period has also ended. It's going to be a while before those comments are sifted through and considered. But onto the changes themselves. There are a number of changes that the Department of Labor has proposed, including adjustments both to the minimum worker pay required for exemption eligibility and the maximum amount of pay that a worker could receive before being classified as a quote-unquote highly compensated employee, or HCE. HCEs generally being exempt from overtime pay. So as for the worker pay adjustments, the minimum amount of pay is being before somebody is even eligible for exemption from overtime pay is being increased from $455 per week to about $679 per week. The job duties test, as we discussed earlier, is expressly not being modified by these rules. As I said before, there's some other rulemaking going on that clarifies the administrative exemption, but there's nothing in this rule that's going to modify the job duties test. That being said, though, there is a new category of job duties, or of professions, really, that are being exempted specifically from these changes. So I'm going to briefly talk about this new category of professions. They are not exempt from overtime. They're merely exempt from this proposed change, this 2019 rulemaking. And the good news is that most people in the audience will not have to worry about this part of the rule because these are professions that are in most places either government employees or they're in a quasi-governmental role. These are police officers, firefighters, first responders, EMTs, that kind of thing. So people in those professions are actually exempt specifically from this rulemaking. But again, these are mostly people who are in the employ of state or town governments. So most people should just not worry too much about this part of the proposed rule. And finally, the proposed rules adjust the salary cap by which an HCE is defined, and they scale that up quite a bit, from $100,000 a year to about $147,000 per year. And just once more to recap, these specific numbers, I think, are the parts of the rule that are most likely to change between now and the final rule. But the actual meat, the substance of these rules, is less likely to change. So perhaps more importantly for payroll professionals, or people who handle the payroll for employees who earn overtime, the 2019 proposal would also create a new tool for measuring which kinds of compensation can contribute to determining whether an employee's salary meets any of these thresholds. So in the past, you may be, at the mercy either of state law or of your own guesswork for determining, is it just somebody's salary that goes into determining their rate of pay? Is it their salary plus the discretionary bonus plus, a holiday bonus or a mandatory quarterly bonus? This rule clarifies that to state that that up to 10% of the minimum salary level can be satisfied with non-discretionary bonuses, commissions, or other incentive pay. So let's take a moment to talk about what a non-discretionary bonus is. So obviously, I want to contrast this with a discretionary bonus. So a discretionary bonus may be something like a holiday bonus that's really only given out if the company has a really good year, if the board determines that employee retention is best served by this bonus that's somewhat out of the blue, not really expected. Whereas a non-discretionary bonus is a predetermined bonus. That an employee reasonably expects to receive. The most familiar context for a non-discretionary bonus would be a sales commission. Usually a sales commission is determined by a prefigured formula that it sort of has a quasi-contract status, where a commissioned salesperson, they expect to receive the commission that's on their commission sheet. So it's non-discretionary in the sense that if the salesperson makes the sale, the company pays the commission, and the company does not generally have the right not to pay that commission. So if a company has entered into a contract or a quasi-contract with an employee, a quasi-contract meaning something like a commission schedule, that an employee has a reasonable expectation of receiving a bonus, that's what I would call a non-discretionary bonus. This may also include, if at the point that somebody signs up as an employee, you tell them that every year there is a profit share. Every holiday season, there's a bonus of 2 paychecks. Any promise that you've made to an employee or created a reasonable expectation in an employee as to receiving a bonus, that should qualify as a non-discretionary bonus. Whereas, what would not be included in this would be, as I said, bonuses that are genuinely discretionary, where the company just periodically may, as a morale-related purpose or to recognize a particular one-off achievement, just grant a bonus to an employee that is truly discretionary and is not based on any promises or anything like that. And I'll briefly continue with what do we do with some gray areas as to bonuses? The most classic example of the gray area that I see in my own practice is, what about a holiday bonus that has never been promised to an employee, but that the company has given out like clockwork for 20 years, every year, to the point where employees have come to reasonably expect them, even though they've never been promised. They're never referenced in any onboarding paperwork, and they're not part of any contracts. These are bonuses that live in a gray area between discretionary and non-discretionary. And my guidance to employers on that kind of bonus is, you really want to try to put yourself in the shoes of a workaday employee and think, does this employee reasonably expect to receive a Christmas bonus this year or a holiday bonus this year? If I were them, would I be doing my financial planning around this bonus? If I've given out a holiday bonus of the exact same rate every year like clockwork, I don't know. I mean, I might want to sit down and say, let's just incorporate this into our employment documents and clarify that this is a non-discretionary bonus, because I don't want to find myself in the position of sometime down the road, an employee comes back and challenges their classification on the basis of what I think is a discretionary bonus, but what they expected to receive, and then we have to litigate around the gray areas of whether that bonus was promised or not. So, as always, my guidance is just put it in writing, clarify your bonus structure, make sure everybody knows what's expected and what's not. Clarity is the simplest way to avoid disputes over payroll. And on that point, this rule, as with any new rule, there's going to be a little bit of catch-up time for everybody to straighten out their payroll practices. So one nice thing about this rule is that it explicitly creates these things called catch-up payments. There's really no equivalent to these under the existing laws, so this is a new concept under the Department of Labor's rules. This concept basically, it acknowledges that new rulemaking is disruptive to payroll, and it's disruptive to compliance. So this rule says that if you make a mistake at some time during the calendar year as to how an employee should be compensated, or in the pay that you make on the basis of overtime pay, you have the opportunity to make catch-up payments, meaning that you go back to the employee and you say, it looks like we made a mistake on your paycheck, on your pay stub. Under the federal rules, we have this right to make a catch-up payment. We are making this catch-up payment in order to clarify the issue. And as long as you make these catch-up payments within the end of the calendar year in which the mistake was made, the employee has no further remedy against you. And this would be true under both state and federal law. So if you make a mistake and you realize that you made a mistake, there's now an explicit carve out under this rule for you to go back, fix the mistake, disclose the mistake to the employee, and you can foreclose yourself from a lot of expensive future litigation over this issue just by going back and making the catch-up payment.
Excellent, Chris. And then I did have a specific question from Chrisanne in the audience. I was hoping we could touch on it since we do have you here, and I don't think I could answer it, but like I said, I want to take advantage of having you today. She asked, is the annual bonus considered a non-discretionary bonus? And she adds, we do accrue for this bonus. So it's
Good. Great question. So, like I said, whether or not an annual bonus is discretionary or not, it really depends on what the employee expects. So, if you give out an annual bonus, but the amount of the bonus varies from year to year, then you sort of got to sit down and figure out, what does the employee expect? If there's no real reasonable expectation about what the employee can expect from a bonus, then I would call that a discretionary bonus. But if you've been giving out the same bonus, say it's 2 weeks pay every Christmas, every year for the last 20 years, then even if it's not set out in writing, I would likely call that a non-discretionary bonus just because the employee has come to expect it so routinely. But again, there's no specific carve out in the rules that clarifies on annual bonuses. It merely speaks to discretionary versus non-discretionary bonuses. And when trying to figure out for yourself from a compliance perspective whether or not a bonus is discretionary or non-discretionary, look at what the employee should expect. So the easy case is the sales commission. A sales commission will almost always be a non-discretionary bonus because the salesperson reasonably expects to receive the commission that's on their commission sheet or their rate sheet, or however you calculate commissions for your salespeople. Whereas if you just every now and then kick somebody $1,000 because they did a great job that quarter, as long as it's not spelled out or promised in writing somewhere, that's what I would call a discretionary bonus. So as to your annual bonuses, sit down and try to figure out what the employee reasonably expects. And my compliance tip, just really quick here, is that if it looks like everybody expects to get 2 weeks of pay every Christmas, just clarify the issue, sit down and put it in writing. It's going to save you a lot of headache and a lot of rethinking down the line. But great question.
Yes, and thank you. And we did get a lot of questions about bonuses, and also going back a little bit to the retroactive pay that you discussed earlier in our pre-registration questions. So definitely thank you for taking out the time, and worked out well. You covered the material that our audience is looking for. So much appreciated, Chris. And just moving forward, I'm sure that most employers are anxious for the final rule to be published so that they know what they are up against moving forward. Do you have any tips on what they can do to prepare for that final rule while they wait?
Sure, Leon. So, like I always say to my clients, the cost of non-compliance is less than the cost of compliance. The cost of non-compliance, especially in overtime and wage and hour issues, can be substantial. There can be tax penalties, in many state laws, including, for example, where I practice in Massachusetts, if you lose a wage and hour related claim or an overtime claim, an employee is going to be entitled to multiple damages in the amount of the money that they should have received. There's your attorney's fees, there's your litigation costs. So, rule number one is just comply. I always caution my employer clients to carefully consult with their own counsel and with their HR professionals before making any determinations. where there's any ambiguity in an employee's, overtime, their regular rate of pay, that kind of thing. So some, just three really quick tips for you guys, though. Number one, that you do want to decide whether or not to make certain payments non-discretionary. So I feel like this bonus issue is where there's going to be a lot of questions from employers and from the public going forward. So my advice is to sit down and you actually do have the ability here to make a business decision about whether or not certain payments are discretionary or non-discretionary. So if you are in a gray zone about your annual bonuses, I would say, sit down with the right management personnel, with your HR personnel, and decide, well, we've been doing this Christmas bonus for every year for 20 years. Let's just sit down and put it in writing and eliminate any ambiguity. That way we're not going to have to refigure this every year, or do a lot of hand wringing about how the overtime is calculated, or about the threshold calculations that we make, because we're just going to decide we're going to do away with the ambiguity. We're going to do the Christmas bonus every year, and that'll be that. So, tip number one is just you get to make that call about whether or not you make certain bonuses discretionary or not. Rule number two, as always, train your compliance personnel in the best ways to monitor future changes in the rule. The Department of Labor always does healthy disclosures about these rules, both when they set forth the proposed rules, when they receive comments, what the comments are that they receive, and then there will be ample time to review the proposed final version of the rules, during which time you'll be able to interact with your legislators and with the Department of Labor about any future questions or concerns. The Department of Labor always puts out these really good fact sheets and other compliance documents that I use in my own practice all the time. Groups like Personnel Concepts always do a great job of keeping us updated on what the latest changes are, and I think that these are great resources for compliance going forward. Number three, again, it should always be clear to an employee whether or not a compensation structure is discretionary. Again, this is easy with your sales staff. With your sales staff, they should always know exactly what their commissions are going to be, and sales commissions really are the bulk of the kind of bonuses that we have to think about here. But for other people who may receive bonuses of a different sort, you just want to make sure it's really clear in your employment documents that you set the employee's expectations. Because if you think back to earlier slides, I keep saying that you want to think about what the employee can reasonably expect to receive as a bonus. And a lot of what an employee can expect is what they hear from you, the HR professional, or you, the payroll professional, because you are the one who cuts the paycheck. So you have a lot of power in this area to clarify, what it is that your employees may or may not expect. And I really encourage everybody to sit down and discuss with your employees what is a reasonable expected bonus for them. If there's going to be a Christmas bonus, just be clear about it. If there's not going to be, just be clear about it. You set the tone for that in a lot of ways.
Thanks again, Christopher. Now, audience, now that you have heard an overview of the proposed overtime rule, we want to hear from you about your plans to react to the rule. So let's take a quick poll. So, if excuse me, if the salary threshold for overtime exemption is raised to 35,000 a year, audience, would you raise people's salary to avoid overtime, A, or B, observe the change but clamp down on overtime, or would you then C, do both? So go ahead and ring in your answers. Once again, that's if the salary is raised to 35,000 a year, how would you react, or how would your employer react there? Now go ahead and we'll close up the responses. Look like we've got a good amount of the audience that has responded, and I'll share those results with you. So it looks like most people would observe the change, but also clamp down on overtime. And a significant amount would also do both as well. So just moving forward, let's switch gears from the overtime, and let's talk about the joint employer rule that the DOL has proposed. Now, could you discuss what the proposed rule would address specifically, Christopher?
Sure, Leon. So at the beginning of April in this year, the Department of Labor announced a proposed rule to clarify the definition of joint employer status. and it would simplify the existing regulatory framework and replace it with a streamlined four-factor test for determining whether or not two or more employers qualify as joint employers. And once again, any professionals in the audience who practice in California will be pleased to see that the proposed new rule adopts almost entirely the existing California test for determining whether or not you qualify as a joint employer with somebody else over a given employee. So the current joint employer rule has not been updated for almost 60 years. The current definition of joint employers, has been defined through a series of, fuzzy, kind of inconsistent tests that have diverged across state courts and between different federal circuits, and this has been a vexing issue for a lot of compliance personnel. That if you have an employee who frequently crosses state lines, or who makes sales both on your behalf and sort of on behalf of a different vendor or supplier, it may not always be obvious whether or not you are a joint employer with somebody else. So the proposed rule is going to harmonize the joint employer definitions across the circuits and across state lines. It's going to preempt existing state laws and different federal court tests for joint employers and just put forward a single streamlined four-factor test. So the proposed new rule is a functional test, again, with four factors. So whether or not a firm counts as the employer, or if multiple firms count as the employers of an employee, would based on whether or not any of those given firms actually exercises the power to hire or fire the employee, actually exercises the power to supervise and control the employee's, work schedules, work conditions, work site conditions, hours of work, that kind of thing, determine the employee's rate and method of payment, and maintain the employee's employment records. So you'll notice that I kind of verbally leaned on the phrase actually exercises. So one thing that's very clear in this rule is that if you have the power on paper to, for example, modify somebody's work schedule or their work conditions, or if you have the authority on paper to maintain the employee's employment records, this is not going to make you a joint employer with somebody else. The new test is very specific that you have to actually exercise one of these powers over an employee in order to be considered a joint employer over that employee. So to be clear, when I say that this rule streamlines the existing test, this rule specifically excludes some tests that have been used in other states or among different federal circuits for determining joint employer status. So the following are tests that are really sort of going away. There's this concept of the economic dependence test. There was this old test where if, as a practical matter, an employee economically depended upon you, then you would qualify as a joint employer over that person, even if you never hired that person, you never kept their records, you never cut their payroll, but they depended on you. This would be very common in a staffing agency context, for example, and this test is thankfully going away because it was a confusing test. As I said on the previous slide, if you have the ability or the power, or if you've reserved a contractual right in relation to an employee, so if you have the theoretical ability to exercise a certain power over an employee but never actually do so, there were some state laws which said that this mere theoretical power was enough to make you a joint employer, and this test is going away. Certain business practices were included under state law and different federal circuit tests for determining joint employers. I'm speaking now mainly to the franchisor-franchisee model. So in many states, if you are in a franchisor-franchisee relationship with an employer, then the franchisor and the franchisee may both be determined to be the employers of the franchisee's employees. You may recognize this in the litigation over the McDonald's employees from a couple of years ago, where this business model test was really at the heart of the government's case. And this new rulemaking is doing away with that rule. Again, a confusing, nebulous rule that created a lot of vexing compliance issues that is thankfully going away. And finally, certain business agreements compliance are used to be considered as possibly creating a joint employer status. So, for example, if you required one of your vendors to maintain certain workplace safety measures, or if you required some of your suppliers to have certain wage floors, or if you required some of your business partners to comply with your sexual harassment policies, any of these kind of contractual modifications to another business's working conditions, in some places may have made you a joint employer with that person. Again, you can see how this, like all of these other tests, creates a lot of confusing questions, creates a lot of compliance issues, and these tests are all going away. All of the tests that you see on this slide will be done away with under the proposed new rule, all to be replaced with that simpler four-factor test that we discussed on that slide. So we've been talking a lot about what makes you a joint employer. Let's talk about why do you care if you're a joint employer? What does it mean to be a joint employer? So a joint employer, it is what it sounds like. You and another business are both the employer of the same person if you meet all of the factors in the four-factor test. So here's why you want to avoid that. Joint employers share in liability in wage and hour actions, meaning that if you are a joint employer with another business and an employee is, they're underpaid, their overtime is improperly calculated, there's some liability that accrues there, that employee now sort of has an a la carte option of who they sue over it or who they go to the EEOC over it, because both you and that other employer share jointly and severally in liability over wage and hour actions. Similarly, joint employers, they share in the responsibility for complex benefits compliance like ERISA compliance. And, I do a lot of work in ERISA compliance, and I can tell you that if you don't want to be in the business of ERISA compliance, you really want to avoid it as much as possible because ERISA is a very complicated statute. How you manage people's retirement plans, how you invest people's retirement funds, how you manage their health care and their health insurance. These are very complex compliance issues. So you really want to avoid being in a position where if one of your business partners, one of your vendors, your suppliers, your staffing agency mismanages its ERISA compliance, that one of these employees over whom you are a joint employer comes to you looking for a compliance remedy, that can be a very expensive process. So you really want to avoid joint employer status for that reason as well. Joint employers share in tax penalties for failure to make proper payroll withholdings. So, as I mentioned on a previous slide, these tax penalties for failure to withhold payroll properly can be very expensive. There's a statutory 12% interest rate on payroll withholdings that you fail to do timely, plus the actual amount of back pay, plus other remedies that both state and federal tax authorities may have. These can be very expensive. So you really want to avoid joint employer status if you want to avoid this kind of expensive tax penalty as well. But finally, joint employers are jointly and severally liable for all of this kind of misconduct. So as I said with the first bullet point, this gives the employees of joint employers this sort of a la carte remedy scheme where they basically get to choose which employer they go after. If I'm an employee and I have two or more employers, and one of my employers is this tiny mom and pop store, but they're joint employers with an enormous conglomerate that I think has deeper pockets, I now have the option of where I go for my remedies. So, I really want to encourage you to take a hard look at whether or not you want to be in a joint employer relationship with some of your business partners. But the good news under this test is that at least now it's easier for you to know. There's a simple four-factor test that speaks to the actual powers that you exercise over workers that will make it much easier for you to tell if a proposed business arrangement will make you a joint employer with somebody.
All right, thank you, Chris. And we've all heard your recommendation and your advice to avoid joint employer status. So thank you for that. But if you don't mind, could you go over the proposed joint rule and who it may apply to? What type of businesses would be greatly, in fact, impacted by this rule, and what they should do to prepare if they are a
Sure,
joint
Leon.
employer?
Sure. Yeah. So, I think it should be pretty obvious that the firms with the most urgent need for compliance reevaluation under this proposed rule would be those that are, involved in mutual control arrangements over employees, especially mutual control over compensation. So I'm speaking mainly to staffing agencies, for example. If you are a staffing agency, or if you do a lot of work with staffing agencies, you're going to want to sit down and look at the contracts that you have either with your staffing agency, or if you're a staffing agency, with your clients, to make sure that it's very clear who is actually exercising certain contractual powers over employees. So, like I said when I was discussing the factors in the test, the test is specifically addressed to actual exercise of contractual rights over employees. So if you're a staffing agency, you want to make it really clear who's calling the shots on hiring and firing, who's calling the shots on raises and bonuses and that kind of thing. If you've done your staffing agency right, this should already be very clear in many of your contracts. But I would encourage you to sit down and reevaluate some of these agreements just to make sure that you're not inadvertently becoming a joint employer with your staffing agency or with your clients. Those who are involved in healthcare administration, TPAs mainly are who I'm speaking to here. So if you're a TPA, you are generally heavily involved in the day-to-day management of healthcare costs, retirement planning, that kind of thing. And so for the same reason that staffing agencies should do reevaluations, you should as well, just to make sure that it's clear who is actually exercising contract powers over payroll and over hiring and firing. And finally, if anybody is involved in a complex franchising or a complex licensing model, one where there's a master entity that, maybe just controls IP or just controls real estate for franchise locations, but you may have a really detailed franchise agreement with your franchisees that may set certain required standards for who is hired, who's fired, who gets paid how much. And if you actually exercise power over your franchisees, for example, if you are in the habit of ordering your franchisees to fire someone, you may want to really sit down and reevaluate how much discretion you want to give to your franchisee. Because in all of these arrangements, whether you're a staffing agency, whether you're a TPA, whether you're a franchisee, you really want to make sure that the discretion over employment decisions lives with your partner, so that it's clear that whoever is exercising a discretionary power over employees is the employer. Because if you're both actually exercising these discretionary powers over employees, you may find yourself in a joint employer relationship that may cause you to share liability where you don't want to, if you're heavily involved in the day-to-day operations of your partners.
Thanks again, Chris, for going over that joint employer rule. And just moving forward into the third of the triple play, could you tell us about the DOL's third proposal addressing the regular rate of pay rule?
Sure, Leon. This relates quite a bit to the overtime calculation that we were discussing in the first chapter of this presentation. So, in March of this year, the Department of Labor also announced a proposed rule to clarify the regular rate of pay. This speaks to determining the amount of overtime payments. So, as we said, when you calculate somebody's overtime pay, you multiply their regular rate of pay by 1.5. Now, if somebody is just getting paid, 15 bucks an hour, it's pretty easy to calculate what 1.5 times the rate of pay is. You take 15, multiply by 1.5, multiply that by overtime hours, and you're good. But there are other ways to pay employees where it was not always obvious what factored into this regular rate of pay. For example, many state laws have variation about what kind of pay gets inserted into that calculation. What about commissions? What about bonuses? What about travel pay? What about mealtime pay, which is one that we'll focus on later on. And so the proposed rule clarifies this by proposing to exempt each of certain items from compensation from calculation and in an employee's regular rate of pay. So one common one would be the cost of providing wellness programs. This may be on-site specialist treatment, gym access, fitness classes, employee discounts on healthcare-related goods and services. And so, this has been a vexing compliance problem because, for example, it's not always easy to determine what is the real value of a gym membership, what is the real value of an on-site nutritionist or an on-site dietary specialist. How do you calculate that for overtime pay, and should you calculate it for overtime pay? So this kind of compensation, as with all of the ones that we'll discuss on this slide, you no longer need to consider under the proposed rule when calculating an employee's regular rate of pay. Payments that were related to unused paid leave, including paid sick leave. If you were operating under a compensation regime where an employee would be paid, just cash for the value of unused leave, you might be in a position of wondering, do I include this in overtime pay calculation? The new answer is no. As with all the items, the answer is going to be no. Reimbursed expenses, anything that you reimburse, even if the reimbursement is not, quote unquote, solely for the employer's benefit. If you reimburse travel expenses, and that includes, actual, airline tickets, but also things like, meals at the airport or other expenses that may not be specifically related to the business. If you reimburse these expenses, you were previously in a position of not knowing for sure if overtime pay should include these reimbursed expenses when figuring out what to multiply by 1.5. Again, these are going away, so you don't have to factor these in. Back to discretionary bonuses, for example. We talked in great detail about what is or is not a discretionary bonus. So one thing that's helpful about this rule is that it at least clarifies for us that discretionary bonuses no longer need to be factored into an employee's regular rate of pay when determining overtime pay. Payment that's related to benefit plans, including accident plans, unemployment plans, legal services, even where these plans, especially unemployment and accident plans, may be required under state law or may be required under your GSA contract. These kinds of benefits, even if they're guaranteed to an employee, even if they're non-discretionary, to be clear about that, these specific kinds of bonuses, even if they're non-discretionary, are no longer to be included in your overtime calculation, specifically for benefit plans, whether or not they are discretionary. And finally, tuition programs, which again, whether or not the tuition program is discretionary or non-discretionary, if you are in an arrangement where you reimburse tuition or you prepay tuition, any kind of tuition bonus will never be included in an overtime calculation under the proposed rule going forward. So one that we really want to focus on, though, is an important clarification related to callback pay. So, callback pay just meaning that you have an employee where, we don't know if we're going to need you tonight or not. So, just sit by your cell phone until, say, 6 o'clock. And we'll let you know by 6 o'clock if you've got to come in, and we'll comp you for the time that you're sort of on call. So when this rule talks about callback pay, that's sort of what it's talking about. So the rule now says that if callback pay or if callback arrangements are, quote unquote, infrequent and sporadic. So let's say, 1 day out of a month. There's no specific definition of what infrequent and sporadic means. I think maybe once a month is safe. If you give callback pay and it's infrequent and sporadic, that's now excludable from an employee's pay. But again, going back to what sounds like a discretionary versus non-discretionary concept, these payments cannot be so regular and predictable that they're essentially, prearranged. Another kind of pay that I said we would focus on is mealtime pay. So, tragically, Mealtime pay is not being specifically addressed by this rule, even though mealtime pay is one of the most common compliance issues in wage and hour compensation. What the Department of Labor is saying is not that mealtime pay is going away. They're not saying that mealtime pay should or should not be included. They're now just saying that your current compliance regime related to mealtime pay does not need to react to this rule. So if you have a state law that specifically addresses mealtime pay, that's great. Keep complying with that state law. If you have no state law and you just have a bonus that relates to mealtime pay or payments related to mealtime pay, just there's nothing that needs to be reevaluated under this rule, because this rule specifically states that that it does not address mealtime pay. So unfortunately, we don't really know what mealtime pay is going to be changed. There may be future rulemaking on mealtime pay. I think that's likely, just because it's been so confusing so far. But this rule does not really address mealtime pay. So what this rule does say, though, is that it does expressly override any inconsistent state rules on what gets factored into overtime pay. So, for example, many states, including where I practice in Massachusetts, say that the cost of your wellness program has to be factored into your overtime pay. But fortunately, that's going to be going away. Any state rules that require you to factor in the cost of anything that we said on the previous slide, those state rules are being overridden. They're being replaced by the federal rule, which says that you now exclude this large category of payments from your overtime calculation. But that being said, you're going to remain free to enter into private contracts with your employees or collective bargaining arrangements with your unions to determine that you should add more compensation into overtime pay. So to be clear about that, even though you no longer by default have to add in, for example, your tuition plan to your overtime pay, you are perfectly free to enter into a private contract with an employee to do so. If you have somebody who, they're really, really worth keeping on board, but they've got a complex tuition requirement, or if they really need an on-site wellness plan to maintain their health, you are perfectly free to contract to bring that person's overtime pay up to include, wellness plans, tuition plans, travel, that kind of thing.
Once again, thanks again, Christopher. We greatly appreciate you reviewing that information. Now, we did want to do a final poll before we get out of here today. So after hearing today's presentation, audience, we want to know from you, which of the following pending rules will affect your business? I'm going to go ahead and launch it now. Everyone look at the poll on your screen. And once again, we want to know from our audience, which of the following pending rules will affect your business? Please choose all that apply. Don't just choose one, choose all that apply. We'll give you just a few seconds here, and I'll share the results. So it looks like the overtime exemption is a clear winner there. With second being the regular rate of pay, not as many joint employers for our audience today. So thank you for reviewing that information. And then, of course, we still have the 6% that aren't sure at this time. So they'll just have to wait on that final rule. But just moving into the conclusion here, Christopher, do you have any recommendations for our listeners as to what they can do to prepare for that regular rate of pay final rule?
Sure, Leon, and I think that this poll is actually consistent with my expectations. I think that for most people, it'll be pretty clear whether or not you stand in a joint employer relationship to somebody else. So I don't think that's something that most people need to worry about as much. But one tip, one nice thing I can say is that number one, a big advantage of the proposed rules is that they expressly do away with a lot of state-by-state variation. A lot of the compliance work that I do has to do with saying, if I have employers that operate in New Hampshire, which is a live free or die, as we say, state, but they cross over to do business in Massachusetts, which has a very complicated, California-style compliance regime, they used to have to worry about a lot of really complicated new compliance rules. But in a lot of cases, a lot of this state-by-state variation is just going away. You're going to have one test for joint employer. You're going to have one rule for overtime pay. You're going to have one rule for overtime eligibility. So I think that's going to help out a lot of people with their compliance. But number two, big tip as always is set out your overtime obligations in writing. Number one, because the employee's expectations determine a lot of your compliance requirements here. Setting out your overtime obligations in writing gives a lot of clarity and really helps to set expectations. Just sit down and address what your overtime pay is. Just put it in writing so that it's clear to everybody. This is especially going to be true for employers who offer other kinds of compensation. Definitely make sure that your sales commission schedules are in writing. But for everything else, if you sit down and make your compensation clear in writing, you are going to be gravy for compliance on most of these things if you've set the expectations very clearly, because a lot of these complicated discretionary, non-discretionary issues address what the employee's expectations are. So really set that out in writing. Same with bonuses, same with holiday pay, quarterly bonuses, especially if you give out bonuses regularly but haven't set them out in writing, just sit down and set the expectations in writing. Send a memo to your employees saying that that this bonus is based on the performance of the company, and so we cannot guarantee it on any given quarter or on any given year. Or what, guys, we've given out this holiday bonus every year for 20 years, so we're just going to say it's part of your compensation now. You're going to get 2 weeks of pay every holiday season, and so that kind of thing is going to really set the expectations for your employees. Just once again, clarity about what I as an employee can expect is the absolute, that is the compliance standard for a lot of these issues. These are long rules, these are confusing issues. There's a lot of text in these rules, but a whole lot of your compliance burden goes into setting the expectations and setting the pace on compensation.
Thanks again, Christopher, and thanks to our audience. So we are quickly approaching 11 o'clock, and we do want to maintain the structure of the webinar and make sure that we are getting everyone out on time and that they hear everything that they need to hear today. So we will just be answering one or two questions from our audience before we move on. And once again, thank you, Chris, for considering our audience and answer the questions. So I do just have one question from Evelyn that I want to pose to you, because it probably will affect the majority of our audience today. Now, Evelyn asks, are there restrictions on changing an hourly employee to salaried? She asked specifically in the construction industry in California, so you can address that if you'd like. But if to our broader audience, Chris, can you think of any restrictions on changing an hourly employee to salaried?
Great question, and this is an issue that I see a lot. So, one thing that's important to consider is that whether or not an employee should be paid hourly or salary, that's a decision that's up to you in a lot of ways, as long as we're clear, though, that the exemptions for example, overtime are not discretionary. The test for whether or not somebody is eligible for overtime has to do with their compensation and with their job duties. So if you have an employee who is on salary, but their job duties and their pay don't exempt them from overtime, and that salaried employee works more than 40 hours in a week, you will still need to figure out their overtime on the basis of multiplying their salary by 40 hours per week. So this is a complicated issue, and we're running out of time. So I'm going to ask Leon to just please feel free to submit these questions in writing so that I can give you a more detailed and lengthy answer, because it is a complex question. But long story short, it is a business decision whether or not most employees should be compensated on a salary or an hourly basis, with the very clear statement, though, that whether or not you pay somebody overtime, or whether or not somebody is eligible for overtime, or the amount of their overtime is not as discretionary. So you may pay somebody on an hourly basis or a salary basis, because that's administratively easier for you guys. But even a salary employee who works more than 40 hours per week, if they don't meet the overtime exemptions, you've got to pay them overtime, multiplying 1.5 times their salary plus any non-discretionary pay, plus some of the other concepts that we discussed in today's webinar. But great question. And please follow up with me afterwards because, again,
Absolutely. And with this being a triple play,
it's a
we've got
complicated
three.
issue. I'm
Yeah,
not going
we've
to be
got
able to
three
answer
rules
it
that
in detail in just the short amount of time we have left.
right. And we're trying to get all three rules into this 1 hour, so we definitely appreciate the audience patience with that. Unfortunately, we have run out of time, and all unanswered questions will be forwarded to Christopher via email, and his responses will be sent to all attendees in the next coming days. And we did get a few questions about the presentation. You will also receive the presentation and the recording today as well via email. So thanks to everyone who submitted questions about today's topic, and thanks to Christopher for taking the time to answer them. Now, here at Personal Concepts, we enjoy hosting webinars for our valued customers, and as such, would really appreciate your feedback. Please stick around for a couple minutes as a brief survey will open for you to rate what you saw and heard today. This concludes today's webinar. Thank you for attending today's presentation. We hope you found this information useful in understanding the recently proposed rules under the DOL. Thanks again to Christopher for being our guest panelist. We look forward to continuing to work with Christopher on future presentations. Now, if you've enjoyed today's webinar, we invite you to view past webinars on demand at the link provided on the screen. And to all of our attendees, thank you for choosing Personal Concepts as your provider of workplace compliance solutions. Have a good afternoon, everyone.